Ladies and gentlemen, welcome back to the IndieZone here on YouTube. My name is Kathy. I am recording this the morning of December 5th, 2024 on the East Coast. And I just checked the court docket in Idaho versus Kohberger, and there still has not been any new filings since November 26th, when the defense filed a stipulated to motion to refile documents concerning the defense's request for a Franks versus Delaware hearing under seal. So it's been almost 2 weeks now. We're expecting some filings, hopefully before the end of the week. This is Thursday, so that would be tomorrow. And until then, we will continue to check the docket and, of course, report on any new filings both here and also on our podcast, which is the IndieZone. We've been covering Idaho versus Kohberger dating back to the very first filing, which was the December 29th, 2022 Affidavit of Probable Cause, all the way up to the aforementioned November 26th stipulated to motion on the Franks matter. Because we deal with facts, not fiction here at the IndieZone, both on YouTube and in the podcast, we've spent a little bit of time while we're waiting for some new items to drop, providing on the community page quizzes on the record to test your knowledge on the record. And I know that my viewers and subscribers on both here at YouTube and on the podcast are from all corners of where they feel the matter stands. Some feel that the evidence on the record proves that Mr. Kohberger is guilty. Others feel that he is not guilty, and still others will not make a determination until or unless more of the evidence, which I describe as a Mount Everest of evidence, is unsealed. This pretty much mirrors my own family situation, because at my home, my husband will not make a determination until he sees the evidence under seal. My son believes that there is no possible way that the authorities would have pursued Mr. Kohberger in the manner that they have had, given notice of their intent to move for the DP in the event he is adjudicated guilty, if they didn't have substantial evidence that may still be under seal, demonstrating that he is the sole and the correct defendant. And then there's my sister, who feels he's a scapegoat. So we have had multiple conversations since this case came to light, and everyone respects everyone else's opinion, and I'm glad that that's the same here, and I welcome everyone's opinion wherever you stand on the matter. My principal concern, as I have stated time and time again, is I am deeply worried about the multitude of documents that are under seal. Some that, in my opinion, should not be under seal. That is my opinion that I continue to give pursuant to the First Amendment of the United States Constitution. So while we're waiting for more filings, if you go to the community page, you'll see a couple of pop quizzes testing your knowledge of the case. And if you have not taken them yet, I would suggest that you stop, come back to this episode of the IndieZone on YouTube after you've taken the quiz, and then see how you fared. So this is a spoiler alert that I'm giving. We're going to give the answers to the last two pop quizzes that we put up. The most recent one, speaking of the documents that are under seal, have to do with the non-dissemination order that was put into place in this case back when it was being prosecuted in Latah County. It's still in effect today. Some people call it the gag order because it prevents parties from doing what they might otherwise do, which would be to, sometimes you'll see state attorney, prosecutor, or defense counsel giving interviews after hearings. We don't see that here because of this non-dissemination order. So the last question that appears on the community page asks about the non-dissemination order, and specifically it states as follows, and I'm going to read right now from my notes. Which group went to the Idaho Supreme Court and then made an appearance in Latah County in an effort to set aside that non-dissemination or AKA gag order? The first answer is A, the Media Coalition / interveners. The second answer, B, State of Idaho AG or the Attorney General's office. The third is the surviving family members of all 4 of the victims. And the fourth, which is D, is the University of Idaho. 62% so far have gotten this correct. So you definitely are monitoring the docket. This goes back a very long time. If you didn't get this correct, that's probably why there has been so much that's happened in about the year and a half or more that these events took place. The correct answer is A. The Media Coalition interveners first went to the Idaho Supreme Court in an effort to get this non-dissemination order set aside under the First Amendment and pursuant to other reasons. And what the Idaho Supreme Court said is, look, we are a court of last, not first impression. You should have filed your action in Latah County first. You do have standing, meaning you have a stake in this action, because you just can't walk off the street and go in and be a party in a case. The Idaho Supreme Court found that the Media Coalition, the interveners, did have standing to intervene. And that's when, after the Idaho Supreme Court case was closed, the interveners / Media Coalition then began filing paperwork in Latah County seeking to have that non-dissemination order set aside. And if you look at the docket, you'll see there were multiple members of the Media Coalition that were local in the Moscow-Latah County area. Some were state in the Idaho or right over the border in Washington State. And some were national as far away as from New York City, demonstrating just the amount of interest that this case, which I think right now is unequivocally the biggest true crime case in the United States. So the answer here was, it was the Interveners Media Coalition, answer A. And unfortunately, in my opinion, they were unsuccessful because, as we know, the non-dissemination order remains in effect as of today. And just as a side note, answer C was only partially correct. One of the families did attempt to get that non-dissemination order set aside through their counsel. So, but that answer C, asked, did all of the surviving family members of the victims do so? And that is clearly a false answer. So that was one. The second pop quiz that we gave talked about when, as of now, and again, this is December 5th, 2024, is the next scheduled hearing before Judge Hippler, at least that we know of on the public docket that's been noticed. When is that set to occur? Is it December 18th, December 19th, and if necessary, the 20th, both of 2024? Was it January 22nd, 2025, or January 23rd, and if necessary, January 24th of 2025? And 76% of people who took this poll got it right. So you are absolutely keeping your eye on the docket. This information comes to us from the October 9th pretrial and trial order that Judge Hippler signed. And it says that the next scheduled hearing is happening in January of 2025, the 23rd, and if necessary, the court has also set aside the 24th. And this relates to the motions to compel discovery and motions to suppress. It's unclear if Mr. Kohberger is successful in getting this Franks hearing that he's looking for, if that might happen on the 24th of January, because again, the court has set aside that date for oral argument if necessary on other matters. And we've seen how quickly Judge Hippler goes through things. He runs these hearings like oral argument. We saw it with the motions that the defense filed to strike the death penalty. He doesn't have you come up and speak forever if you're the defense or if you're the state. Your arguments are already in the motion and the replies if you are the moving party. And if you're not the moving party, your position is in the response. Judge Hippler has already read it at oral argument, which he might set aside 20 minutes. In one case, he set aside for one of the DP motions 40 minutes. That is, in my opinion, the time to get up there, to hit hard on your most important 1 or 2, maximum 3 points in your motion, and be prepared. Anticipate what Judge Hippler may ask and respond to those questions. So that is, again, the correct answer, and you can look at the October 9th, 2024 order to find this. It's on page 2 under the section entitled Motions. And finally, I just want to give, if I could, a shout out to our podcast. It is the IndieZone, Kathy's IndieZone podcast. You can find it on numerous platforms where you listen, I'm sure, to other podcasts. Our home platform is Spotify, but we are on several others, such as Amazon. We're on many others. Listen Notes is one that includes a very powerful search engine. So in other words, this docket is massive. If you want to do research, or if you just want to read, for example, the matters that dealt with the non-dissemination order, you type that in, it will pull up the episodes that I've done. It'll give a brief analysis and description of what's in that podcast episode, again, 5 minutes or less, and it will tell you exactly the date of the filing, so then you can go to the docket, which is extremely long right now, and some of the titles do not reference with specificity what is in that document. So hopefully, if you're doing research, if you're a podcaster, if you're an independent journalist, that will help you save a lot of time that you might otherwise have to spend going back to a year and a half ago, for example, when these issues regarding the non-dissemination order first came into effect. This will now conclude this episode of the IndieZone. This is Kathy. As always, I want to thank you for your time and for your attention today.